People will often ask me, how will my filing bankruptcy affect other people who might be jointly liable on debts with me? And the answer to that is it should have very little effect on them. When you have a joint debt with someone else, the law provides that you're 100% liable for the debt and the other person's 100% liable for the debt. In other words, the creditor can try to collect the whole amount from you, or they can try to collect the whole amount from the other person, or they can collect 40% from you and 60% from the other person. But both of you are liable for 100% of that joint debt. Now, if you file bankruptcy, the filing of a bankruptcy petition does not increase or decrease the joint debtor's liability on their debts. In other words, they're still liable for that debt. They're still 100% liable for that joint debt. But when you file bankruptcy, if you wipe out your liability on that debt, then of course the only person that the creditor can go after is the joint debtor. So you're not increasing their liability, but on the other hand, they're now the only one who's liable on the debt, and that's the only one that the creditor can focus on. Now you can avoid that joint debtor from having any problems by continuing to pay the debt. In other words, when you file bankruptcy, you wipe out your legal liability to pay a debt, which means that the creditor can't force you to pay the debt, but if you want to pay the debt voluntarily, you can continue to do so. So if I was to file bankruptcy and my brother is jointly liable on a debt with me, I can protect him even though I don't have to keep paying that debt. I can protect him by continuing to do so.